Okay.
This is on, so we're all set. Let me call to order the Town of Waxahachie Grove Special Magistrate hearing for today. Today's Wednesday, September 18, 2013. It's a few minutes after 10. And my name is Bill Doney. I'm the magistrate. I guess we're going to have witnesses. So let me swear in the witnesses, whoever's going to be testifying. I guess you folks, you're probably not. But,
As an attorney,
you don't need to, unless you're testifying as the individual. Okay. Do you swear the testimony you'll give will be the truth, the whole truth, nothing but the truth?
I do.
Good.
First case is the Waxahachie Groves Hastings matter, and I guess no one's here on that, and we have someone present on the second case, right?
Right.
Okay, so why don't we skip to that and we'll come back to Hastings. This is, it's listed under fine reduction hearing. Is that what it is, or what do we have? Continuance? It's actually a continuance hearing?
Yes, so it's a continuance.
Okay.
Could you give me 1 minute now to set up?
Yeah, let me do that, and I will just sort of call the case. It's Waxahachie Grove versus Magic Properties, and it's case 2008-067. So we're here on a requested continuance. What's up?
I'm a little bit confused. I spoke to Bev before the hearing, but what we're in compliance with the violation after quite some time.
Wow, yes.
We're pleased to announce that, and so we're here to respectfully request the mitigation of the fine.
Okay, so this is fine reduction. Or is it?
Yes,
Well,
I have in the past when we've done when the fines have been reduced. This has been set up because it was when we first brought it to you, it was a fine certification hearing, and of course the fine was put into abeyance, and so we advertised it as a continuance of the fine certification.
Okay, so we'll sort through exactly where we are with it. Since we have the court report here, why don't we have everybody enter an appearance on the record, and then we'll go from there.
Russ Ellison, Code Enforcement Officer, Town of Waxahachie Groves.
Beverly 2, Code Enforcement Director on behalf of the Town of Waxahachie Groves.
Mark Cutney, Town Manager, Waxahachie Groves.
David Coviello with the law firm of Chefs and Bowen on behalf of Valley Crest Properties, also known as Magic Properties.
So actually, it is your motion or your request?
Yes, sir.
Okay. And let me, I know this case has been around, let me refresh my memory here. There was a violation finding, is that accurate?
Yes, sir.
There was, and then was there a fine imposed?
No, sir, there was a fine advance.
Okay.
On November,
Do we have the orders that have been entered?
yes, sir. Would you like for me to go through real quick?
Yeah, you can maybe give me a summary, or I can just take a look.
I'll do a real quick summary, and we'll re-enter the important information. Mr. Magistrate, this is Beverly 2, with 2 and Taylor Inc., serving on behalf of the Town of Waxahachie Groves Code Enforcement. If you recall, there was a citizen complaint made on 3/19/08 against Valley Crest. It said that the complaint was the landscape maintenance should be on commercial property. I will re-enter that as exhibit number 1 for today's hearing. Courtesy correction notice was provided to Valley Crest on March 24th, 2008, and requesting a 30-day compliance date. What the violation is, section of Waxahachie Groves Unified Land Development Code, Article 4, Section A, Section 3A, Table 4.A.3.A-1, Chapter B, Section 1A.77. Landscape service permitted in this zone only, area only in conjunction with a retail or wholesale nursery, requiring 30-day compliance on the courtesy correction notice. I'll provide that as exhibit number 2. There was a notice of violation provided on August the 7th of 2008. Again, same ordinance, regulation, and description, 15 days to comply. I'll provide that to you as mitigant loss in the exhibits, exhibit number 3. Then, Mr. Magistrate, if you recall when we first brought this to you, I think I need to add to the record that this whole case began with a completely different administration. A special magistrate that we do not presently utilize, a different code enforcement agency which is presently not utilized, and a different town management staff.
We all inherited this.
We've all inherited this case.
No wonder I don't remember it that well.
Yes, sir. Yes, sir. There was an order finding violation. I'll provide this as exhibit number 4. The order of finding violation was signed by Special Magistrate Karen Roselli. The order was signed on September 10th, 2008. The compliance date was set for December 10th, 2008. And if no compliance was obtained on or before that date, a fine was imposed in the amount of $100 per day. After that time, Mr. Magistrate, what appeared to have occurred was that there was some action on behalf of the employees of Valley Crest to make an attempt to comply. I am going to provide this as exhibit number 5. This is a zoning confirmation response that was responded to by a zoning technician in Palm Beach County. The date on this is October 15th, 2008. So again, it does appear that there was some attempt to respond to the order. This is a zoning confirmation request form back to Harold Worthington with the Valley Crest Companies. Now the interesting thing, and I think that I'm just going to go on ahead and put it on record because I'm going to come back to this in just a few minutes as I go further into my presentation. The interesting thing, Mr. Magistrate, is you will find that the county had indicated what you will find in the order is there's no presentation, there's nothing which indicates in the order what the zoning is on the property. Okay? In this letter for the zoning confirmation response form, what it indicates is that the zoning district was Agricultural Residential District AR, Agricultural Residential. Now, where it gets a little bit bizarre in the case is that the county stated in this letter that the subject property is regulated by an approved site plan and should conform to the development regulations and characteristics as denoted on the approved plan. That's been a while ago, but I think this is important and pertinent to the case. This was submitted as a previous exhibit. And the county goes on, and you got to understand that in this request, the request was from Mr. Harold Worthington to please confirm that wholesale nursery is permitted and that a landscape service can be an accessory use on the property. The county goes on to indicate that even with the zoning district being agricultural residential district, that a wholesale nursery would be required as a primary use with the landscape service as a secondary use, and also with the approval of the site plan by Palm Beach County. And there was, again, I don't know if the site plan, I did submit it previously, if it was submitted at the same time, but there is also evidence that there was an attempt to comply and move forward with putting a wholesale nursery on this property and using that as the primary permitted use, as well as having a secondary use as the landscape service business.
Okay, just to refresh my memory, at the time, this is toward the end of 2008, the town was still utilizing the county's uniform land development regulations?
Yes, sir.
Okay, so when did that turn over?
The actual date was
August.
November 16, 2010 was when the ULDC came into effect in the town.
Okay, let me just ask counsel, do you have any objection to any of these exhibits?
Yes.
All right. Just catch up with myself here. Since that time, Mr. Magistrate, this case went completely cold. There's no evidence of any additional paperwork, any additional correspondence since the 10/15/08 letter from the county. Cannot find any evidence that anything happened on it whatsoever. Completely went cold. When Sue and Taylor took over the code enforcement services for Loxahatchee Groves, this is one of the cases that we were asked to bring forward, to move forward, and to come to some sort of resolution on. As a result of that, we did bring this case to you as a fine certification hearing on November 16th, 2011, and at that point in time, all fines were placed in abeyance and stopped to run at that point because Valley Crest was very much in agreement in moving forward to complete some sort of resolution. And at that time, moving forward in a manner in which a nursery would become the primary use on the property pursuant to the agricultural zoning district of ARR, which required that in addition to a site plan approval, the nursery would have to be a primary use and the landscape service the secondary use. So that was the plan at that point.
So the town zoning pretty much was consistent with what the county's zoning was?
As it turns out, no sir, and I'll bring that up in a minute. As it turns out, and I'm sure Council for Valley Crest will even make this a little more clear, what happened, Mr. Magistrate, is that once Valley Crest got into the site plan approval process, it was determined that the property was not zoned ARR, even though, and it doesn't state in our order finding violation, it doesn't state what the zoning district was. But the ARR zoning district pursuant to the Palm Beach County Code was that, yes, indeed, that in addition to a site plan approval, they would have to have the nursery, and the nursery would have to be primary to the landscape business in the ARR zoning district. As it turns out,
Can I just interrupt? I think you're just maybe confusing. It's the AGR, which requires the nursery, and we're zoned AR.
AGR, thank you, the A, and for the
It's complicated
record, not
enough.
ARR,
Yes.
not ARR, the AGR. Mr. Magistrate, they are actually zoned AR, agricultural residential. And as agricultural residential, what that means pursuant to the Palm Beach County Code is that the wholesale nursery isn't required to be the primary use. The landscape service can be the primary use so long as they have a site plan approval from the Palm Beach
Subject
County.
to county commission approval.
Right, subject to Palm Beach County approval. Clear?
I think I have it somewhere. But there is no AGR, or there is an AGR,
There is an AGR.
Yes.
but it doesn't apply here.
Correct.
Okay.
Our only zoning district was AR in town.
Yeah, I was gonna say, I had never heard AGR in town. Okay.
So with that being said, and as Mr. Coviello had indicated, they have been found, they have moved forward in Loxahatchee Groves. They did go through an extensive and lengthy and timely, and I'm sure
I was gonna
costly
say, and expensive, no doubt.
site plan approval process, and I am going to submit for you exhibit number 5, which is exhibit number 6, which is resolution number 2013-05, which allowed or approved their site plan in order for them to operate in the AR district as a landscape business, no nursery operation required.
Do you have a copy? Did you indicate there was a 2011 order that I signed?
No, sir, there was no 2011.
There was no order. It came in, I vaguely remember something happening on this. Was there any order entered at all?
No, so there was no order entered, it was just that you had indicated on the record, and I've got the record here, where the minutes where it was put into abeyance and continued. So now, if I may move on.
Yes.
Okay. So here we are today. You have been, The notice of hearing fine certification continuance has been advertised. The property pursuant to state statute, we have posted and also provided certified mail copies to Magic Properties and posted the properties. I'm providing that to you as exhibit number 7.
Okay, so this is really what was set for hearing today, correct?
I'm sorry.
Okay.
You see that?
Yeah, this indicates a fine certification continuance, and after seeing this, I emailed this too, and questioned that, and actually questioned the agenda as well. But what, as far as I know, and I think we're on the same page, what we're here today for is to mitigate the fine,
Okay.
because in fact we are in compliance.
Yeah, let me take a look at what went down here. Okay. Okay.
Okay to continue? Okay. Since that time, Mr. Magistrate, we have, and I believe you, it was provided to you, the request from Mr. Coviello with Johnson Bowen on behalf of Magic Properties, or Valley Crest, to go through an iteration of a fine reduction. And so it was provided to you, but I am going to submit it as an exhibit. This is a letter dated September 10th, 2013 from Mr. Coviello. Exhibit number 8. And if I may, I'm just going to refer to that letter as this part of my presentation and kind of work my way through it. And certainly, Mr. Coviello may jump up and down so fast, I don't know about that, but you have a turn.
That's the September 10th letter, right?
Yes, sir.
Okay.
You have a copy.
I have a copy with exhibits. I'll submit it with exhibits if that's okay.
Yes.
During my presentation.
And you're probably going to find that yours will be additional, or my exhibits are going to probably be your exhibits.
Okay.
That's fine. Okay, Mr. Magistrate, if you will look at the first page of the letter, under item number 1, the calculation of the fines, the town agrees with that. Since December 11th of 2008 through the date in which the fines were held in abeyance on November 16, 2011, the total calculation would have been $107,100. We agree with that.
So there's an agreement that would have been the amount,
Yes, sir.
or is the amount, I guess?
That
So,
is-
just so I understand the posture of it, there was a window of time that the fine ran, and then in November of 11, I put the fines in abeyance.
Yes, sir.
Okay, so there's no fine was running from then forward.
Yes, that's correct.
That's correct.
Okay, so this 107,000 is 100 is for that prior time.
Yes, sir.
Okay.
Absolutely. You will find on page 2 of Mr. Coviello's letter, item number 2, the mitigating factor number 1. We've taken a look at this, and certainly I'm going to go on ahead. This whole portion of mitigating factor number 1 is regarding certain ordinances that the town put into place at that time in which they were making an attempt to move forward and to adopt their own land development code as well as their comprehensive plan. What these ordinances did essentially was to put all different types of planning and zoning and comprehensive plan reviews on hold until the adoption of the land development code and the adoption of the comprehensive plan. So with that being said, I am going to provide you, going ahead, and I'm just going to provide you one exhibit that includes and encompasses Resolution 2007-07 regarding the moratorium on development permits. It also includes Resolution 2009-002, Resolution 2010-001, and Resolution 2010-004. If we were to take a look those fines that would have been running at that period in time in which these resolutions were effective, the fines, just looking at this item number 2, mitigating factor number 1, would have totaled $75,200. So that would have been the fine at that point in time as it's applicable to those resolutions. The one thing that I'll go ahead and put on the record, Mr. Magistrate, is the fact that some questions have come up to town staff, particularly code enforcement, related to questions such as, well, Bev, even though the most moratoriums were in effect, we still had Palm Beach County, and we were under contract with Palm Beach County to route and to have Palm Beach County review and approve development applications. So with that being said, if in fact that is true, which I cannot answer that question today because I do not know, and I don't believe that the city manager knows the answer to that question, that would have meant that regardless of the town resolutions, there still was a path by which Valley Crest could have taken to receive a site plan approval.
Okay, so I understand that point. You're saying that you're not sure, but potentially a property owner could have gone to the county for site plan approval or whatever in this window period, and therefore the town's moratorium would not have precluded moving forward.
Correct.
Okay.
That's one of the questions that is outstanding. So moving on to mitigating factor, or to item number 3, which is mitigating factor number 2. There's a whole discussion about, and you've heard me bring this discussion up and with previous cases, Resolution 2009-010. There was a period of time in which, and I'm going to pass that to you. This one you've seen before, Mr. Magistrate. I've used it before. There was a point in time in which Loxahatchee Groves decided that, yes, in fact, there may have been some inconsistencies with what the county had in their land development code and what Loxahatchee Groves wanted to do in their land development code, and there were code enforcement cases that somehow had got stuck in between the county and the town of Loxahatchee Groves code. As a result of that, what the town of Loxahatchee Groves did is they said, okay, we understand that, so therefore we're passing this particular resolution, 09010, and we're going to pretty much put all code enforcement cases in abeyance until the adoption of the town's comprehensive plan and land development code. The town indeed did adopt the land development code in November of 2010, and the comprehensive plan was adopted in August of 2011. And you'll find in the resolution it was at that time in which the town adopted the land development code and the comprehensive plan that the moratorium for code enforcement would be lifted. So it would have been lifted on August 27, 2011. So with that all being said, we do not disagree with Mr. Coviello and with Valley Crest that that indeed is true. And that the fines that would have been running during that period of time would have been held in abeyance. So we certainly agree on that particular mitigating factor number 2. Correct. Now moving forward to mitigating factor number 3. This is where and why I've kind of already put into the record this whole discussion, because I'm sure that Mr. Coviello is going to bring it up, and I'm sure we're going to have to come to some sort of terms and agreement with all of this. But we also, at this point, do not agree with mitigating factor number 3. Which states that pursuant, and this is from Mr. Coviello's letter, page 2, item number 4, mitigating factor number 3, that pursuant to the notice of violation issued by the town, the owner was cited for having a landscape service business in a zoned area that only allowed such business in conjunction with a retail or wholesale nursery. I'll stop right there and point out to you that the town of Waxahachie Groves and the previous code enforcement staff never even indicated a zone, a zoning designation in the notice of violation. For whatever reason, I don't know. The regulations, moving forward with the letter, the regulations cited in the notice of violation are Article 4, Chapter A, Section 3A, Table 4, .A.3A-1, and Chapter B, Section 1A.77, which states exactly as Mr. Coviello has entered into his letter, with Article 4, Chapter A, Section 3A, Table 4, .A.3A-1, which states that it provides a landscape service business is permitted in the applicable zoning district subject to the approval by the Board of County Commission. Then it goes on to state, Chapter B, Section 1A.77, it provides that a landscape service business is permitted as follows. In the AR district as a principal use, and B, subparent B, in the AGR district only in conjunction with a retail or wholesale nursery. So again, I'll just reiterate.
Let me stop you there so I
Yes,
understand.
please.
And this may get to more of the argument, but at the time the property was cited, it was, what was the zone?
AR.
AR, okay. And the AR does not require the landscape business to be in conjunction with a nursery?
That's correct.
Didn't under the county, doesn't under the town?
That's correct.
Is that
No, the county does, in the town.
No, to his question. In the AR district.
Yes.
Yes, what? Ask the question again, Mr. Magistrate.
Well, I'm just trying to sort through here. At the time the property was cited in 2008, I know the notice of violation does not indicate zoning category, but it was AR, I'm understanding correctly.
Yes.
It was AR, and under county zoning, if I'm tracking this right, the county did not require the landscape business to be complementary or in conjunction with a nursery. You could just have the landscape with county commission approval?
In the AR district.
Okay. And I guess there was no county commission approval.
That's correct. So either,
And though, as we're going through this history, there was a site plan approved at some point by the county?
no, sir.
No.
No. What the violation states is, again, all the violation does is just give you the citation for this particular section of the Palm Beach County Code, which encompasses Article 4, Chapter A, and Article 4, Chapter B. And regardless of what the zoning designation is, a site plan approval was still required. That's the bottom line.
Now let you respond if you disagree with that, or do you agree or disagree?
I agree that a site plan approval was required under the county code, but there were two aspects of the violation, and we were directed, pursuant to the violation, to incorporate a nursery. And that, as I think we're on the same page, the zoning district has never required a nursery to be a part of the landscape business. And of course, Valley Crest is a landscape service business and always has been, and so we've gone through this entire process thinking that we've had to incorporate a nursery, and that's why it's taken quite some time.
Okay.
Okay. Any more questions, Mr. Magistrate?
No,
I'm gonna
continue.
wrap it up here. So our bottom line being is that, and our recommendation at this point, town is going to recommend that an amount of, okay, town is going to recommend that in regard to page 2 of Mr. Coviella's letter, Roman numeral 2, mitigating factor number 1, as I indicated, those fines as they relate to the ordinances, the total would have been $75,200. The town would agree to split half the difference and request a fine in the amount of $37,600 as it relates to that particular item. The town also, if you recall, we agreed that Mr. Coviello and Valley Crest was correct in their evaluation on page 2, Roman numeral 3, mitigating factor number 2. We've agreed to that particular mitigating factor. We do not agree with Roman numeral number 4, mitigating factor number 3, and we are requesting, as a result thereof, for a fine, in addition to the $37,600, an additional $8,100. Plus, we are also requesting the administrative costs, and I'll provide that to you as exhibit number 11.
Just to clarify, if you're accepting mitigating factor number 2, why are you adding $8,100 to your proposal?
I had the same question, because 8,100 is the one under factor 2.
Because 80, if you,
Happens to be the same number.
what happens is if I accept mitigating factor number 2, and I take the fines that would have ran from see, I told you we were going to take and you look at what's left over, and I take the dates when the fine was where we're running, it's actually $75,200 plus $8,100. That's what it should be. And we're saying that we will mitigate to half of the $75,200
Plus 8,100 or?
plus the $8,100.
Plus it. Okay. I guess where I'm getting a little lost on that, and I understand it's, proposal sort of is, if you add up the 8,100 and the 8,100 and the 75,000, that doesn't come to 107,000, or should it?
Well, no, because there is, you will have, if we agree to to Mr. Coviello's analysis in Roman numeral number 3, mitigating factor number 2, we're telling you that we agree with that during that time in which resolution 09010 was in effect, that the fine should have been in abeyance. We're agreeing that we will allow that, and we agree to putting those fines during that period of time into abeyance.
And that's 8,100?
No, the remainder is 8,100. That's what I keep trying to say. That would be, I don't have my calculator.
Right.
Okay. Take out. It would have been a,
No, we're just doing,
yeah,
the end of 31, I think 31. That gives you that number.
7,500.
The 8,100 should be the deviation or something, that's what we're
Right, right.
Okay.
Yeah, I mean,
Okay.
what's the difference was it?
Okay.
Right.
Okay.
Right, we're still stating that the total costs are $107,000, $107,100. We agree with that. The total fines that are associated in Mr. Coviello's page 2, item number 2, are $75,200. Is that correct, Mr. Coviello?
Repeat that, I'm sorry.
$75,200. Is that correct?
What figure is that? I'm not understanding.
$107,100.
Correct.
What you've done is you've taken the $107,100 and you have taken and itemized those in each one of those mitigating factors to get the 0.
Correct.
So mitigating factor number 1 is $75,200.
That's correct. If you accept mitigating factor number 1, the remaining balance of the fines is $31,900. Therefore, you're deducting the 70-some-odd thousand that you referred to.
Correct, which we're stating that the town is agreeing, out of that $75,200, we're stating that we do not fully agree with your assumptions in Roman numeral number 2, but we will put into abeyance and forgive half of that amount, leaving $37,600 as itemized in Roman numeral number 2. It's half of $75,200, correct?
Correct.
Okay. Then when we go down to item Roman numeral number 3, mitigating factor number 2, there still is remaining a fine in the amount, or additional fines in the amount of $31,900, correct?
I'm sorry, no, I don't, I'm not following it, I don't agree with that.
That's for 30 seconds.
Can we ask for the 30-second continuance?
Yeah, let's take a break. Mr. Hastings, we passed over your case since you weren't here, we didn't take any action, so we'll get back.
Do you want me to join you guys, or?
No, I think we'll get it to
It was 10:30.
It was 10, but you're okay.
There wasn't any math involved, we'll be fine, right?
Why don't I have the lawsuit?
Okay, I think we're on all the same page now.
Hold on a second.
What else is?
Let me let you do that because I probably won't put it on, and I won't be recording it.
Just press record, right?
Yes.
Okay, we're back on the record, and maybe we've reached some agreement.
Yes. Maybe what I should do is just put a recommendation together for the total amount. The total, what the town is requesting in fines is a fine of $45,700. I believe we all agree with that number, no matter how we arrived at it.
Yeah, I agree with the calculation,
Okay.
but I'm not agreeing with the number.
Okay, you'll have your
Now,
choice.
that's your recommendation.
The recommendation, again, $45,700 is
Based
our
on these,
recommendation.
based on these legal arguments, but is there additional reduction based on standard mitigation factors like good faith, clean record, et cetera, et cetera?
You may want to make that presentation to the magistrate.
Understood, thank you.
Let me ask, just so I understand that, I see the number of 107,000, but then I read in the mitigating factors that, I'm just trying to figure out what the fine would be. I'm not seeing the 107,000. If the original fine would have kicked in pursuant to the order finding violation December 10 of 2008, correct?
Correct.
And then there was the moratorium was imposed May 19th of 2009.
You mean
The
the,
moratorium,
which moratorium?
That was the moratorium on enforcing code.
Oh, no.
November 7, 2007 is when it was
I think it's talking about a
moratorium.
different, which resolution, Mr. Magistrate?
Okay.
I know what now?
Well, I'm looking at, 2009, 010.
Okay, that's not the moratorium, but
That's the abatement of
yes,
enforcement.
that's correct.
Right, okay. So I guess what I'm trying to just sort through, if you look at it, as I look at that, then you have a window where the fine could be imposed from December 10 of 08 to May 19 of 09.
Yes, sir, and the number, no matter how we arrived at it, is still $8,100.
It's 81 days. Well, no, it's more than 81 days. It's 4 months.
It went from,
It was like 5 months. Well, maybe it doesn't matter, but I'm just trying to think through how, I mean, if there's an agreement that once May 10, 2009 hit, the fine shouldn't have been running.
right,
Is there agreement on that?
That's correct.
Okay, so we have from December 10 of 08 to May 19 of 09, and they may contest this, but there, you have that window of time where the fine could have been running, right?
That's correct.
Okay, and we could figure out how many days that is, but it's, say, 20 days in 08, and then another, whatever May 19 is.
Well,
And then we have a window of time when there was the abatement of enforcement of code violations.
Mr.
That's the window that you just referred to.
Yes.
was started May 19 of '09, right?
May, you're right. That's the abatement.
That's the abatement.
And then there's the moratorium that started even earlier than that.
But the moratorium was on development orders and permits.
Site plans, development, yeah.
Right,
That started in November 7, 2007, actually before the fines agreement was voted.
okay. Okay, maybe I'm unduly confusing it, but,
Mr. Magistrate, if I can, I apologize, but I have another commitment and I'm going to have to leave in about 5 minutes. So let me, if I can, let me just make a statement on the record, and then that way as you continue, you can go through this from the town's position. So I assist Ms. Tu with this. From the town standpoint, we agree with the arguments that Attorney Coviello is making as it relates, mitigating factors. They, since the time when you ordered them to go and address the issue back in 2011, they have been outstanding. They've paid their cost recovery issues. They've made every attempt to do the site plans, so I do want to give them credit for that. The only issue that hangs in the balance in the town's mind, we recognize the issue with the moratorium as well. The problem is substantiating or at least verifying what the applicant may have done during that moratorium period, or whatever, to try to appeal to the council that, hey, I'm in this situation, I need some type of relief in order to address the situation. Unfortunately, without further digging and research, and Lord knows if we'll ever find it anyway, but that's the one thing that we can substantiate. That was the reason why we were trying to look for a number, and why I pretty much halved it to the 75 to the 3075 and trying to come up with some kind of number. So essentially the number that we're at now, the 45, Mr. Coviello will make those arguments, I'm sure, and I guess from the town standpoint, we would, we're certainly willing to listen to them. It's just that we can't say we forgive totally, because we're not in a position to do that. But obviously, anything that you may determine, in taking all the arguments that Ms. Tu and Mr. Coviello are going to give you in my absence, we would, we appreciate your looking at that.
would you like the opportunity from the town side to dig deeper, or is that probably a lost cause as far as finding something?
We don't have a problem with that to maybe one continuance. I think that's something, Mr. Coviello would have to agree to. Obviously, if we do it one continuance, our attorney will be representing us as well, so I don't know, if it's going to leave it up at that point or not. But as far as attempting to find any further information, I know in discussing with Mr. Coviello, he doesn't think we're going to find anything substantial, so.
Yeah, we've gone to great lengths to try to find documentation. We've actually tried to track down the prior code compliance officer for the town with no luck, and the files that unfortunately are not complete from our perspective. So I think that these are issues that can be decided today. I don't know that it's.
Yeah, it doesn't sound like there's much sense putting it off. We're not going to know much more in a month. Okay.
I just wanted you to understand the town standpoint where we're at, the number, and obviously that can be mitigated further, but taking into account all the arguments and go.
Okay, got it.
Thank you, Mark.
Anything else from the town? I heard a recommendation. I heard it from Mr. Cutney, so I guess you're done.
My recommendation still is that we are recommending that certainly that the total, out of the total fine amount of $107,100, we are agreeing to a fine mitigation to some extent, and we are in agreement, the town is to mitigate the fine down from $107,100 to $45,700. Be happy to stand for any questions. Oh, excuse me, Mr. Magistrate, I did not, as well as the administrative costs, but I do need to submit this as exhibit number 11. And the administrative cost in the amount of $1,147.50.
That's
Sorry,
right.
what was that? 1,147?
Yes, if you can pass that around, Mr. Coviello.
That's an extra.
Okay, and there is, let me just ask this question, in the order finding violation, there's a $400 cost amount. Is that inclusive of whatever you just gave me?
Yes.
Okay, so that's your number's a total.
Yes, sir.
Who have you got?
Oh, Mr. Magistrate, that's an addition to you said.
Yeah, because your time looks like starts in 11, so this is.
$45,700 plus $1,147.50 plus $400. And we'll stand for additional questions and comments.
Okay. You're up.
Okay, Mr. Magistrate, I apologize if I repeat some of what Ms. Tuba said. I think it's important to go through some of the facts here. First, I'd like to start on the notice of violation that was issued, and I believe that's in the record already.
Yes.
If you look at the description of the notice of violation, it says that a landscape service is permitted in this zone area only in conjunction with a retail or wholesale nursery. Okay, that was the violation. If you look at the zoning code, which was cited above, it's chapter B, section 1A77. That section has two sections, one for the AR district and one for the AGR district. The AGR district, which we're not located within, indicates that it shall only be permitted in conjunction with a retail or wholesale nursery. So it's clear from the notice of violation that they lifted the language from the AGR district, which was never applicable to our property. Alternatively, the AR district, above that, indicates that a landscape service business is permitted as a principal use so long as two requirements are met. The property is located on a collector or arterial street, and the minimum lot size is 3 acres. And we satisfy both of those requirements. So the entire premise of this violation from the beginning was improper. I should say a portion of the violation was improper. Valley Crest, as I stated before, is a landscape service business. We've been operating like that on the property. And so what we simply had to do was go in and obtain site plan approval to allow that business to continue. We didn't have to go through the hoops of incorporating a nursery component.
Okay, let me just stop you there and ask a question. At the time the order finding violation was entered, did Valley Crest appear at the hearing? Were you?
Unfortunately, Valley Crest was not retained by council, and so
Were they present at all?
I don't know.
It's hard to tell from the order.
I believe that Harold may, well, of course you weren't here as well. But
No.
I believe a representative may have attended. I'm not sure if it was the original original violation hearing.
Okay, go ahead.
But I just lay that out because, we have gone through a substantial process and based on a faulty premise, and I think it's important to point that out. Now, the other half of the violation, of course, and I'm in agreement that Valley Crest did need to obtain site plan approval for its landscape service business. And, that wasn't done when they moved onto the property, not in bad faith. They just didn't realize that they had to do that. With that said, that leads into the mitigating factor number one. The only way to comply with the violation was to file a site plan application. And so as a result, and let me hand out, I should have done this earlier, but this may help the timeline.
Yes.
Explain the timeline.
I don't know, copy, please.
Sure. And I have this on a PowerPoint, but unfortunately this morning I realized that the PowerPoint was corrupted, so
Okay.
printed it out here. But okay, we're all in agreement that the calculation of fines on the first page is $107,100, and the date range is there. I think there's no question about that. The next point is that the moratorium was adopted on the filing of all site plan applications in the town on November 7, 2007. Okay, so from that point up to when the moratorium was lifted in January 1, 2011, that sort of light gray area, fines should not be imposed during that period because the only way for us to come into compliance was filing a site plan application, and we were precluded from doing so. Now, I realize that an issue was raised or a question was raised as to whether we could have gone to the county and filed a site plan application there. And I respectfully disagree with the notion that we could have done that because once the town incorporated, we're subject to the jurisdiction of the town. Regardless of whether the town uses the county services to process site plan applications, that moratorium was passed for property within the town. And so there was no way that we could have, whether it was through the town process or the county process, the purpose of the moratorium was to stop development orders while the town had the opportunity to adopt its own code and comp plan. So I don't think that we could have done that. With that said, my client did not sit on its hands. They first went to the county and filed a zoning confirmation response, which confirmed that the property was zoned AR, which we now know, asking whether they can do a nursery with a landscape service business, because again, the violation was issued for that. And so, not having counsel at that point, they were just going along with the violation and acting in good faith to incorporate a nursery. Once they got the response, they developed a site plan. Couldn't go through the formal site plan review process because of the moratorium, but they did work with Calvin Giordano, the prior code compliance company, and developed the site plan. I believe that site plan is within the exhibit submitted. If not, I can submit it.
Is this it?
Yes, that's correct. And as you can see, the client attempted to incorporate a nursery component on the property. And actually went so far as to do that, and this has not been submitted, but here's an aerial of the property back at that time from Google Earth. And it does show, if you compare that to the site plan, it does show a nursery area roughly in the area that's shown on the draft site plan.
Okay, let me do this so we have the record. We'll make your timeline, your exhibit 1, and we'll make this Google Earth aerial exhibit 2.
And so if you compare the draft site plan that we worked out with Calvin Giordano, and I admit the records are not as tight as we all would like them to be, but nonetheless, you can compare that with the aerial, and you'll see that they made a good faith effort to incorporate a nursery component. So although their hands were tied with respect to a formal site plan review, they did do something. And it turns out that nursery ultimately was damaged because of a bad winter, but nonetheless, they've attempted in good faith to do that. So from our position, and you also have these ordinances in the record, it's clear that these ordinances prohibited the filing of any type of applications for site plan or any other type of development approval. Now, there are a number of exemptions explicitly outlined in these ordinances, in the moratorium ordinances, and none of which pertain to us. So, typically you may have an exception that says, exempt site plan approvals that are tied to code compliance matter. But there is no such exemption in the moratorium that allowed us to move forward with the site plan. So from our perspective, on the timeline, the area in light gray should be eliminated, and fines, in good faith, fines should not have been accruing to that time. That leaves us with $31,900 as the base mitigating amount after mitigating factor number 1. Then you go to mitigating factor number 2, and I won't spend much time on that because I think the town agrees that mitigating factor will further eat into the balance, which is $31,900, and further reduce it to $8,100. Because that abatement was from May 19, 2009 to April 27, 2011. So the timeline that we're left with is April 27, 2011 through November 16, 2011. And that's the $8,100 this month. And our position is that that remaining balance should be further mitigated, number 1, because the entire premise of this violation was faulty to begin with, and we've spent approximately $100,000 to go through a process of incorporating a nursery and going through multiple site plan hearings based on a faulty violation. With that said, I agree that we did have the obligation to file a site plan application. It would have been a lot easier and a lot less costly to simply go in and memorialize our current business and not have the nursery in place. So we believe that that 8100 should be further mitigated because the entire premise of the violation is faulty. On top of that, under Florida statutes, you have mitigating factors. The way I see these factors in my letter as legal issues, we have the mitigating factors in Florida statutes. Number one, did the violator act in good faith? Was the violation egregious? Is there any other violations on the property, prior violations or current violations? And I think that we have acted in good faith. This is, as Mark pointed out, this entire violation and this entire process was in a very, very complicated transition from the county to the city, the change in jurisdictions, change in zoning codes, change in code compliance personnel, the growing pains of a new municipality and having to adapt to their new processes, which may have took longer than what they should have taken. Number two, the fine is, it's a violation, but it's not an egregious fine. We're not talking life safety. We're talking about a use that was permitted, but just wasn't memorialized on a site plan. And so I don't think it was an egregious violation. And it certainly wasn't, we didn't intend to do it. Number three is that the property has had no prior violations and no new violations, for example, for property maintenance or anything else. And so we've had a clean record. We've acted in good faith, we've worked with the town closely, and so we're respectfully asking that the fine be reduced to zero.
Do you know when the site plan was prepared?
I have a timeline here. Unfortunately, it's not dated, but that site plan, it was between November 2008 and February 2009. And by the way, Mr. Magistrate, after that site plan was prepared and we worked with the code compliance officer, we hadn't heard anything from the town, and so we assumed that the issue was resolved. And whether that was valid or not, whether my client should have assumed that or not, they assumed it was taken care of. And in fact, we didn't hear anything until we were re-noticed in November 2011. And so this isn't a situation where just, lying dormant. I mean, we did something, we thought it was taken care of, my client didn't have counsel, and then we were re-noticed for a hearing to reappear.
Does the town have record of the site plan?
That's all I have with the site plan.
But it was part of the town file, or?
That was Giordano's file.
That was part of the code enforcement files in the town, yes.
Okay, so it was presented at some point, formally, informally, whatever. I mean, it was.
Somewhere.
Yeah,
Where, I don't know.
yeah.
And if I may make just one other point, on the issue of the moratorium was, at that point when the moratorium was in place, the county was contracted to provide site plan approval services. Okay, so if it meant that we can go to the county, if it was meant that we can go to the county and get site plan approval, and the moratorium only applied to town site plan approval processes, the moratorium would be meaningless because the town wasn't handling site plan approvals at the time. It was the county. So I think it can only be interpreted as a moratorium on site plan approvals within the town's jurisdiction. Whether the process is with the county or the town, I don't think you can say that because the only process was with the county at that point. The town didn't have its process.
But this site plan was part of the prior code enforcement officer's file.
Yes, or along with the request.
The zoning confirmation letter?
Yes.
Okay. Were you done?
Yes, sir.
Any response?
I'll just reiterate again that, as far as the resolutions that were being referred to, if anything, we would request some additional time to do some further investigation if you choose to do a continuance. And then in terms of the justifications for the mitigating factor number 3, the bottom line is still this, and that is, at some point, someone within Valley Crest was moving forward to produce a response to a zoning confirmation request and to produce a site plan. So we do know that there was some action on their part to move forward. Nonetheless, the bottom line is that, and the town's notice of violation does not include a zoning district, but nonetheless, that under that particular portion of the land development code for Palm Beach County that was cited, it does leave 2 options available for landscape business, whether they be in the AGR or whether they be in the AR. And in both instances, Mr. Magistrate, site plan approval was required. There was a period of time in which a site plan approval could have been obtained, but it was not, whether they forgot about it, whether they did not move forward. It wasn't caught until the point until we brought them back for the fine certification. And the other thing that I'll just respond to, Mr. Coviello, is that in looking at the fines, I have completely kept the problem and the situation that occurred for you within the planning process separate and independent. So if you believe that there was a problem due to the situation whereby you were moving forward and getting a site plan approval for a nursery, I would have hoped and believed that you've addressed that with the town council.
Okay, just a couple responses. I disagree that I don't think there was a window, if you review the moratorium provisions and the abatement, I don't think there was a window for us to apply. And I didn't understand your last point about you would have.
Well, there would have been a window to have
No,
at
no,
least
the
come,
second
there
point.
would have, may I respond to the first point? There would have been a window. There would have been a window as of August 27th, 2011, for the initial resolutions where site plan review went on hold. As of January 1st, 2011, and November 16th, 2011, that was the date of the moratorium.
Yeah, the only
You
one,
may be
the only
correct.
window was April 27th, 2011 to November 16th, 2011.
But you were talking the second, that's correct, so
Yeah,
there-
that's
it would have been a very, very minor window.
But and
But
I just didn't understand your
the
second.
second point is, I have to, I understand the situation that occurred when you found yourself in the planning process for the town. And in that planning process, you were moving forward, and I'm only, and correct me if I'm wrong, but I understand you were moving forward with the nursery as the primary, and then someone came back at some point during that process, whether it be you or the town attorney, and said, oh, well, you were AR, so why are you in here with a nursery?
Yeah,
So, but
important
that's
to clarify.
something that, and I understand the cost that you incurred as a result of that. And I would think that that would be something that I believe you've addressed with the town council, because that was a cost in the planning process, not as part of the fine and the fine mitigation
Understood.
process.
Mr. Magistrate, if I could just clarify that, because I think it's important, is that we discovered, when I was hired, we discovered that the violation was an error. And so when we started the formal site plan review process with the town, once we had the ability to do that, in meeting with staff, not Deb, but the town planner, we decided to move forward with the nursery. Number one, because the order required it. And number two, the town's new zoning regulations prohibit a landscape service company anywhere in the town. And so under the town's current regulations, our use is no longer permitted. And so to sort of soften our request, we said, you know what, we'll incorporate the nursery to come more in line with the town's current code, even though this is all governed by the county code, because that's what we recited. So we were trying to be, in dealing with staff, we came to the conclusion that we're going to act in good faith, and we're going to bring this closer into compliance with the town code, even though it doesn't apply, and because the violation, the notice of violation required us to do so. So that's why we went with the nursery route. And then we went to the town council, they said, you know what? Okeechobee Boulevard, why is what's so bad about a landscape service company? Why do we prohibit these now? Come back to us a second time and get rid of the nursery component. So it's just, we're told to do one thing, you need a nursery component, that was wrong. We decided to do it because the town now prohibits our use. Then we can go through a 2-year process to put the nursery there. Then we get to the town council, and the town council says, you know what? It's not so bad after all, you're a landscape company. Get rid of the nursery and keep the landscape company. So our heads are spinning, but we've done everything we could along the way in good faith. And again, it's cost a lot of money. Now, on the issue of continuing this and researching additionally, with all due respect to them, these arguments I sent to the town on August 12, 2013. And so the town attorney, whoever else had to review these arguments and review these moratorium ordinances could have done that. It's been a long time.
Okay. Is your thought you would like to review more things?
I believe, Mr. Magistrate, if there was that additional review, that there could be, and perhaps the possibility that our assumptions, the town's assumptions regarding the mitigating factor number 1, Roman numeral 2, could potentially change. I will say that in that particular case, it could change maybe down. I don't know if the town's going to come back and say, oh, well, we decided we want the whole $75,200. So if anything, I would think that perhaps there could be a little more comfort on the town's part, and possibly even perhaps a reduction even further.
Okay. Let me do this then. I don't mean or don't want to delay this and understand your comment about the town having time, but I really haven't had a chance to read any of this myself. So it's, you know, I can pick a number, I mean, which would be just picking a number more or less. It would help me to have a little more time, I think, to review the things and then come back and see if you give the town a month to find what you can find. And then I'm hoping we don't need a long hearing. I mean, we have all this stuff already in the record. And then just wrap it up in October, I guess. Do we have a date for the October meeting?
It's like October 16th here on the agenda.
Okay. So why don't we continue the hearing to October 16th?
Yes.
And did you have a comment on the cost of
The administrative cost?
administrative costs?
No, I don't have a comment on that. I mean, if we were to mitigate the fines in their entirety, I would have no problem agreeing to paying those costs only. Can I make one more comment before we close?
Sure.
Just so it's clear, if we go back, if the town goes back and looks at mitigating factor number 1, I want to make it clear that these are legal arguments as to why fines should not have accrued during that period of time. In addition to that, typically, at least mitigation hearings that I've been to, there's a statutory requirement, or factors that should be considered, which I've outlined. So I would hope that the town would come back and consider those factors as well as a further mitigation point on top of these legal issues.
Do I have, or should I have your letter with the attachments, the big packet?
I can give you a copy. Maybe it would be better to submit this into the record.
Yeah, why don't we make this Exhibit 3, to be on 3, I think, because I have the letter, I guess, but not the attachments. Being the September 10, 2013 letter. Okay, why don't we do that? We will come back in October, see if the town can find anything additional that would be pertinent. Or if you do, I don't know how you would, if you have anything new.
just left one more thing, I'll leave, but. Hey, can we have 1 minute?
Sure, we'll take a break for a moment, and while we're on the record, then we'll take up the Hastings matter. So we'll do that. And I guess I can keep this, we can have one. Okay.
No. Thank you.
Okay, we are back on the record, and we're on to case 2012-311, the town versus 1930 D Road LLC. So what do we have on this?
Yes, Mr. Magistrate, thank you. Beverly 2, Town of Waxahachie Groves Code Enforcement. You recall, Mr. Magistrate, there have been numerous continuances working with the Hastings to bring them into compliance on this particular piece of property at 1930 D Road. And they have, since the last meeting we had, they have come into compliance. I believe the certificate of compliance has been issued, but they have come into compliance. So we have no further code enforcement action against them. Also, the fines on the property have been held in abeyance while they were coming into compliance. However, the administrative costs were still subject for to come back for magistrate hearing. So they are here today. We have provided a notice of hearing for certification of the administrative cost. And I'll provide that to you as exhibit number 1. This notice was issued on August 22nd, 2013, pursuant to state statute. And I have also taken a look at the administrative costs, the costs that were incurred for prosecution of this case. From the prosecution of the case started in October 26th of 2012, initiated by Mr. Elgin, the scheduled appointment with the property owner, and running through September 13th of 2013. I'm going to provide the administrative cost summary, exhibit number 2, to you. The total estimated cost for administrative charges is $3,568.50, and we are asking for that for fine certification in that amount. And Mr. Magistrate, I do have, if needed, all of the backup documentation in terms of how those charges were incurred.
Mr. Hastings, do you have a copy of the cost list?
No.
We need to give that to you.
I'm good.
Okay, and let me do this. You weren't here when I swore the witnesses in. Let me swear you in if you're going to testify. You swear the testimony you will give me the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. And just so the record is clear, your name, please, sir?
Jerry Hastings.
And what is your connection with the 1930
30 D Road LLC.
I'm not sure.
Okay, but you're authorized to be here on behalf of the
Yes.
LLC. Okay. And I guess you know why we're here. The town's looking to tax or charge the costs they have in this matter. And I don't know if you have any response.
Well, I haven't looked at it's the first I've seen of the cost summary, but I do have a response.
Sure.
It's hard for me to imagine that our case, which has gone on less than a year, could possibly have 3 times the administrative cost of the Valley Crest that's gone on for 5 years. It's also my belief that a judge on the West Coast has ruled that the cost of investigating a code complaint is incumbent on the town, and that is considered routine business expenses, and administration fees can't be charged for routine business. It's also my opinion that none of this would have ever occurred had the town acted in good faith when we first were forced to move from 162nd Street. Had the town not singled us out, had the neighbor not complained, had the town said, you can be grandfathered in, all you have to do is ask to be grandfathered in, the town demanded that we move to another property. We've been singled out all along. We're being singled out here. You're asking for 3 times the fee, a case that went up, that had over $100,000 you found in violation, in fines. And you're reducing it to whatever. It sounds like it should be 0 because it's down, but that's a different case. But it's just impossible for me to believe that you want 3 times the administrative fees for less than a year, and you have 5 years of dealing with them. And I know they've been in here countless numbers of times because they've been here when I've been here. I can't retain an attorney. Fine me, do whatever you want, but you'll end up with the property.
Okay. Response? Any response?
No, sir. Mr. Magistrate, I will respond if I may.
Sure.
Just to say you're thinking about Mr. Hastings' comment regarding the administrative costs and the difference between this and the previous case. One of the things, Mr. Hastings, that I hope you understand is that in that previous case, their administrative charges would have been significantly higher if we had also included the previous code enforcement staff's time and attention to that case, which we did not have.
Just another case of me being singled out.
The other situation with that case is once that case went into abatement, the fines were in abeyance and they went into the planning process, we did not do anything with that case for the last 1.5 years, probably almost 2 years now, as a result of them being in the planning process and moving forward in good faith in that respect. So there was no further code enforcement action. So that's one of the reasons why you're seeing the difference in the cost.
Just another case of me being singled out, treated differently than everybody else, not being given the chance to say, grandfather me in. Just another case of you acting in bad faith of not saying, all you have to do is say, let me be grandfathered in here. Don't spend the thousands of dollars to move to another property where we can throw you out of there and run you around in circles for years. Just just another case of me being treated differently.
Okay. Just looking at the time. I'm familiar, I think, with the case you're referencing on the West Coast, and the distinction, if there is one, it is that in that, excuse me, in that case, there was town staff that they tried to tax as costs as opposed to outside contractors. I guess it remains to be seen, you know, with Waxahachie Grove sort of having a different model, how that all would play out. But it certainly, and let me ask the question of the town. The cost summary that you presented, this is all time that has been expended on this matter?
Yes,
And the listing, active rate of flex time and dates of the individuals who did the work?
yes, so they come directly out of the time sheets that are submitted.
Okay. And are these invoices that are submitted to the town, these amounts?
Yes.
Maybe not this precise way, but however you bill the town,
Yes,
these matters get or have been billed to the town or will be billed to the town?
yes, these administrative costs, these services have already been paid to and Taylor. These costs go directly back into the town coffers for cost
So you
recovery.
bill the town for your time in this manner as set forth here. Might be billed in a different format, but
Yes.
it's billed over. Okay, I will then enter an order taxing the administrative costs in the amount specified, and so I will do an order in the amount of $3,568.50. And I guess that's about it. I don't know what else we have to cover. Anything else?
Yes.
That it should be the good news. Maybe that's the end of all this.
You think that's good news? I think I'm being robbed. I think this is a joke. I think this is, you know, I'm looking to get a bill from you for your time.
Well, you won't be one.
Thank you for nothing, for chasing me out of Waxahachie Groves.
Okay. Anything else on our agenda?
I don't think so, not today.
That was enough. It is about 11:45, and we will adjourn.
Thank you. All right, you go back to the town?
I am.
Let me give you this.